Broadcast.
The broadcast is now starting. All attendees are in listen-only mode.
Hello, everybody. This is Dean Roper from WAN-IFRA. I just wanted to come on briefly to say we're going to wait about one more minute because we have quite a few people logging in at the moment, and we will get officially started in about 1 minute. Okay, hello, everybody. This is Dean Roper. Welcome to the WAN-IFRA webinar, Why is GDPR Good for Publishers? Well, most of you probably know that in 2 days on Friday, GDPR officially goes into effect, whatever that means. We're not sure at this moment. But I think what we'll learn today is that Friday will be more or less just the beginning of the journey. There's obviously a lot of anticipation, anxiety, and uncertainty around this topic, and some of this, or much of it, actually won't be sorted out anytime soon, it seems. It's interesting to see, though, that many of you that are attending are actually working outside of Europe. So we have a very global audience, and it's good to know that Robert Madge is here with us today to hopefully clear up some of the issues that are surrounding this topic. Robert has immersed himself in this topic for quite some time now, and critically, hopefully he can tell us a little bit more about why indeed this is a win for publishers. But before we get started, I would like to talk just a minute about our annual World News Media Congress that's coming up in just a couple of weeks in Portugal, just outside of Lisbon and Estoril. And obviously at the Congress, GDPR will be a hot topic, maybe not so much specifically on stage, but definitely people will be talking about it. But we do have 2 or 3 sessions that I'm sure will talk about the topic. One is this one, the future of advertising and data, which will be led by Jason Kent, who is the CEO of the American Publisher Association Digital Content Next. And about the same time, myself and Dr. Francois Nell will be talking about the WAN-IFRA's annual World Press Trends Survey. And I can tell you right now that there will be definitely a few slides about GDPR in that presentation, as GDPR will definitely cast a shadow over the coming year regarding audience, traffic, and definitely revenues. Either way, it's sure to be a great event, and we hope to see you there. So, Robert Madge is the founder and CEO of Xifrat Daten. Robert, I hope I pronounced that correctly. It's in Switzerland. It's a supplier of data-centric services, but on this topic, as I mentioned, Robert has immersed himself in the whole ePrivacy and GDPR issue for quite some time now. Before we get started, I would like to tell the audience that you can participate actively in this webinar by giving us your questions, and how you can do that is you'll see on the right-hand panel, there's a place where you can type in your questions. I highly encourage you to do that, and actually today we're going to try to make this even a little more interactive compared to some of the other webinars we've done. Robert has asked me to gladly interrupt him while he's given his presentation if I have a question or we get questions. So I encourage you to please send us your questions, and we will get to those whenever we can. And now, after Robert's presentation in the webinar, we will tomorrow send out a email to each of you with a summary of the webinar, as well as a link to the webinar that will be on our YouTube channel. So it has a little more life to it than just today. Okay, so without further ado, we will now welcome Robert. So Robert, the stage is yours.
Thank you very much. I hope I pressed the right button so that you can see the screen, see my screen. So thank you very much for inviting me, Dean, to make this webinar, and good afternoon to all of you, or good morning if you're on the western side of the Atlantic. Can I have a confirmation that my slide is...
excuse me, Robert, 1 second. We're not seeing your screen just yet.
Okay, let me try another button. Just a moment. I have a technical problem here that I cannot access the button for the screen. 1 moment.
Okay, now.
How are we doing now? Okay, now we have it.
Beautiful fields of green. So there we go.
Now you have my slides. Thank you very much. So as restart again, my apologies, and good afternoon, everybody. So I will be moving on quite quickly because I'm planning to talk for about 20 minutes, subject to any questions during the course of the talk, and then going into a question and answer session. Obviously, the GDPR is a very complex law, and so this is quite a complex subject, and I'm certainly not going to try and give a general briefing about the GDPR. My intention today is focused specifically on how the GDPR affects the relationship between publishers and advertisers who wish to do programmatic or targeted advertising. So that'll be the specific focus of the topic, but if you want to ask any other questions related to the GDPR, I would of course be very happy to do so. So I'm going to jump in and tell you the end of the story before I start. The spoiler slide to say that the publishers are really the gatekeepers to advertisers, and I'm going to go into the detail of why that is, but it means that advertisers need publishers in order to comply with the GDPR. I've misspelt it. It should say GDPR. Now, of course, publishers rely on the revenue from advertisers in many cases, so this is not a one-sided equation, but it's certainly my belief that the GDPR is shifted the equation to put the publishers in a very strong position. So why discuss the GDPR at all? Well, it's because it governs any collection or use of personal data. It very specifically says it now includes online identifiers, so any IP address even that's collected of a visitor to a website. It certainly covers all cookies used for tracking. Nearly all cookies count as personal data. Obviously, personalized advertising or personalized content depends on using personal data. And so this brings in the whole area of targeted advertising under the impact of the GDPR. And anybody who handles personal data has a lot of obligations. Some of those have a particular impact if you are doing processing in the background. So for example, advertisers, in order to produce targeted advertising, are processing personal data in the background. And this puts them into a very difficult position related to the GDPR, as I will explain. Also, the GDPR overlaps with another law, which people tend to call the cookie law. But it's a separate law, but as it happens, it refers back to the GDPR for anything to do with consent. So where the ePrivacy law says you have to use consent, you then look at the GDPR to see what that means. That's why there's going to be a big impact on Friday. So just to explain what those two laws are, the GDPR is a law that applies to the processing of any personal data, applies in general to any organization operating in the European Union, and to any targeting of individuals in the European Union from outside. And so any personal data then comes under the GDPR. The ePrivacy, it controls the rules in the European Union for electronic communications, that including presentation of information and use of websites. And the ePrivacy, we're currently under an ePrivacy law that's been around for 16 years or so. And there is a plan to put in a new ePrivacy regulation, which might come into effect next year. But in fact, because the ePrivacy existing law depends upon the GDPR for definition of consent, then there's an immediate impact. And I think most of the effect on publishers takes place whether or not the new ePrivacy regulation comes into force. What changes with the GDPR is, as I said, it redefines consent compared to previous data protection law. It makes it stricter, it makes it non-ambiguous, and it makes it opt-in. It creates stricter rules for how personal data is handled. You know, that's why there are 190 provisions or something inside the GDPR. And it increases obligations of transparency towards the individual whose personal data is being used and the rights for that individual. To execute on this transparency and the user rights, organizations have to be able to contact the end user. And I'll keep repeating this word about contact. So cookies require consent. Since 2009, you cannot place a cookie without it having consent from the end user, other than some very specific technical cookies. Any marketing cookie has to have a consent. It has to have a specific purpose, which has to be explained to the individual giving the consent. They have to be informed. They have to know who will get to see the cookie. They have to know how long it will be used for. And you cannot make the cookie as a wall for the condition of service to access a website. You can't make a marketing cookie a wall for accessing a website. And of course, if you can't contact the user, then you can't obtain their consent. With the GDPR obligations, there are, of course, many rules to follow. Informing the users what you're doing, the individuals what you're doing. Again, that needs consent. Responding to their requests, that needs contact as well. And the route of contact could potentially be indirect, but only if it's very formally organized through partnerships. So to go into some more detail, I would say the personal data obligations that relate to dealing directly with individuals happen in the three areas of consents. There are some other legal bases other than consent in general in the GDPR, but not relevant to cookies. Then there's transparency, and then the user rights. So I've described the publisher as a direct controller. The word controller comes from the GDPR. It means the person who makes the decisions about what is done with personal data when they get it from the end user. So in most cases, in nearly all cases, a publisher would be the controller, but there is a discussion that in some cases, it would only be a processor working kind of under subcontract to a controller. But for the purposes of this presentation, I'm discussing it all on the basis of the publisher being the controller. Then if there is somebody else who's not in direct contact with the end user and wants to have their personal data and then make use of that data, that becomes a recipient controller. They receive from the publisher or the direct controller. So as you can see, of course, only the direct controller has the direct contact, at least at the beginning, with the end user. So any consents needed have to be collected by the publisher and by the publisher on behalf of a third party, if a third party also wants the consent. When it comes on to transparency, and a lot of information has to be provided for consent anyway, obviously a publisher might be getting data for its own reasons, but if it's doing it for third parties, then potentially it could be a route to give information to the end user. And then when it comes to the rights that the end user wants to exercise, it becomes even more complicated if people don't have direct contact with the end user. So I'll skip quickly. I'm not going to go into every detail of what's needed to get consent, and the information has to be provided, but it is very detailed. And if there's going to be any profiling involved, which has a significant effect on the individual, then it's even harder to get consent. It has to be explicit, which requires often a double connection with the user.
Hey, Robert, can I interrupt you for 1 second?
Please do.
Yes, I mean, you're talking about consent. We talked about it before. Most of us, I know I have, and I assume many listening today have been bombarded in their inbox with emails asking for consent to opt in to different newsletters and mailings. Now we're hearing that a lot of this actually may not even be necessary. What can you say about that?
There are two main places in the ePrivacy law that deal with the need for consent, the existing law. One of them is to do with cookies and any other information like fingerprinting or anything other information gathered from the computer. And the other one deals with direct email marketing. So most of the emails you've been getting are to do with the email marketing aspect of consent. Because the GDPR is redefining that also a bit, then people are worried they don't have a right to send you an email. So it's not related really at all to the advertising issue I'm discussing, but it is a parallel impact of the GDPR interacting with the ePrivacy law. Mm-hmm. So when it comes to the consent on behalf of a recipient controller, information has to be provided about what that recipient would do, what the advertiser or advertising network would do with the information from the cookie, and other things, how long it's going to use it for and things like this. So if a publisher acts as an intermediary, they are representing information from another party. This leads to very awkward issues of legal liability. So a publisher becomes a middle person, but in a legal liable sense as well as just being a communication channel. Then following on from actually getting consent, there's other information that needs to be provided to the individuals. Typically that's being done at the moment through links to privacy notices. So you click on a link, get it from the website. However, if you had, say, 50 different advertising organizations standing behind this consent, then that would imply that the user was clicking on 50 different advertisers' links and going to their websites to find more information, which is not practical. Furthermore, it then gets to the next stage that when a user says, I want to change my data, I want to be forgotten, I want data portability, I want to download my data and give it to somebody else. These are new rights. And to get those rights, then they have to get to the person who holds the data, which again is very difficult for anyone who's not the direct contact point for the user. So the way that some people have been trying to do it, well, I've got talking about two examples here. One is Google, and they've got various different agreements, end-to-end, but there's one under the AdWords where they define themselves as an independent controller, but they're trying to dictate rules to the controller, the publisher, about how it has, or what kind of consent they have to be. But as I mentioned earlier, the publisher can only get a valid consent if they can provide detailed information on behalf of the next organization that gets the data. And so far, I haven't seen that Google has published that information that would allow the publishers to comply with the law as getting the consent. Nor have I heard how Google plans to fulfill its rights, the obligations it has to meet the individual's rights. Another example is the IAB Transparency and Consent Framework. This one is similar conceptually to Google, where it's saying these outside controllers will tell publishers, the advertising tech companies will ask the publishers to provide consents on their own behalf. But the IAB Europe has been very ambitious and trying to extend this to the whole ad tech industry, creating a fully technical framework where there are standardized rules on the purpose definitions. It creates kind of a networked management of user consents spread among these various different ad tech companies. And it asks the publisher to display the transparency notices. Again, it doesn't say how the ad tech companies will handle individual rights, the exercise of those rights later. And it's a very ambitious framework. I think it's got good points to it, but essentially it seems to be trying to preserve the existing ad tech industry in the light of GDPR, which may well not be viable to this practical problem of how you make effective communications with end users. So I actually believe that most of the data-driven ad tech industry is going to get wiped out by the combination of a GDPR with ePrivacy. This isn't something that happens overnight because people can just carry on doing the same, waiting until they're stopped from doing so.
That's a pretty bold statement, no?
Well, I hardly see how on Friday, even 1% of those ad tech companies are going to be operating legally according to the GDPR. So yes, it's a bold statement, and it's to stimulate discussion. And there will be companies inside that ad tech industry who work out how they can have a future for themselves. In the Google example I mentioned, they only allow up to 12 companies for you to connect to using their agreements. They claim that that is on the basis that end users would not be able to handle the decision-making problems of more than 12 businesses. So out of the hundreds or probably thousands of ad tech companies, if you go via Google, you'll only end up with 12. 12 you pick. So clearly there is no room, there's not enough room for ad tech companies to play a part in this complex consent and information handling needed with the GDPR. So the publishers hold the key to this equation. Publishers have the relationship with end users. They provide the communications. They're being put under a lot of pressure to accept these controller agreements with Google or IAB Europe or with others, and they gives them legal liability as well as technical challenges, and really becomes a question mark whether publishers want to accept that or what they want to ask for in return. Also, whether or not they are going to play any role in the execution of user rights following the consent and use of personal data, because this is a particularly difficult problem for the advertising industry. So I would say that there are, some number of approaches the publishers might take now. One is to accept the rules coming from the advertising industry. And, some people like Google and IAB are stepping up to the table proposing rules, obviously looked at from their point of view. Publishers could adapt and improve the proposed schemes by using what I believe is increased negotiating power that they have in the light of these laws, by accepting the principles of these schemes, but looking for some greater benefit from the role that they provide. In the case of the IAB framework, it's not exactly a take or leave it situation, because as published, publishers can decide which of the list of ad tech companies they're willing to consider for connecting to. So a publisher could decide just to connect to two ad tech companies or 3 ad tech companies out of the hundreds. It don't have to connect to a large number. So this again is a negotiating power that's handed towards publishers, between publishers and ad tech, and also in their relationships with IAB as a grouping of the advertising related organizations. Going further, some publisher groups have already been working on schemes for unified consumer login so that it can provide benefits of extending their relationship to multiple, to the customers of their associated publishing companies, and therefore providing benefits of personalization, ease of use, and a trusted environment to consumers. So that certainly has good potential if publishers cooperate enough in those groups. Another is what I call trusted agents, which are a kind of a consent management network, which are trusted not only by the publishers, but are trusted by the end users. So these are more like independent organizations who provide services to the consumers and the publishers in parallel. And of course, it's possible to establish walled gardens, refuse to accept cookies from companies, focus in the advertising world on contextual advertising and non-personalized advertising, and focus on the personalized content for the users that your own customers, and giving them the best experience. Trusted agents, as I said, are consent preference handling bodies, but having a direct contact with individuals. So individuals put their trust in trusted agents, and they can therefore make it easy by giving a category of consent, which is then automatically applied to the different consent requests without the individuals having to deal with them. They can also act as a gateway on personal data flow to protect personal information. A further role these trusted agents or independent trusted agents can provide is to provide trusted, personalized advertising. The problem with most of the programmatic advertising at the moment is it releases accidentally a good deal of personal information in the bidding process, and in giving information about who has seen which adverts, it also tends to release personal data. And so it needs a very privacy-focused organization to stand in the way of actually delivering adverts to prevent that problem. Just very quickly on trusted agents a bit more. They would record user preferences and the user how it wants to control its activities. And they would store the data and they could, if the user wanted to, conduct profiling within this trusted environment with the user's permission. And then they can add as ad-serving organizations. Now, there's one secret weapon that comes from the GDPR I haven't mentioned yet, and that is the weapon of data portability. Data portability comes to any user whose personal data is used because they have either given consent or entered into a contract. And they can ask for all data that's kept about them. And it appears all data that's been observed about how they've used, what sites they've looked at, which adverts they clicked on and things like this. And they can ask for that information to be transferred to a competitor of the company holding that data. So this opens a door for publishers to get together and set up competitive services where they encourage their end users to download their data from the likes of Facebook or Google or Amazon. And those organizations have to comply free of charge and have to provide the data in a format it can be transferred to a third party. So this is a secret weapon. So that is the end of the prepared slides, and moving on now to any questions.
Okay, thanks, Robert. Thanks a lot. Yeah, let's jump to, we have a question from John, who asked, one second, how can I get this? So John asked, on my publishing site, we only track cookies that analyze page views, time spent per page, and do not collect personal info. Is the standard message of, by accessing this site, you accept cookies? Okay, do we still need to spell out the details of these cookies, he asked.
The test is whether they are necessary for the operation of the site or for a service which has been specifically requested by the end user. So I don't think analytics come in that exception. So I believe that analytics do require permission. Now, the ePrivacy law does not distinguish between personal data and non-personal data. So I think that applies in any case. However, to the question of personal data, I shouldn't jump to a conclusion that something is not personal because you don't send somebody's name. If you keep analytics about an individual, then that will become personal data, because once you have a few analytics about that person, you are starting to describe that person. So only if the analytics are once off would they not count as personal data.
Okay, we have another question from Rinjit, and the question is, does GDPR apply for UK residents' data?
Does it apply to UK residents? It applies to the UK because the UK is a member of the European Union, and the UK has just passed a new act which effectively replicates the GDPR when it leaves the European Union. If the UK resident or EU resident is somewhere else outside the European Economic Area, then the law does not apply unless it's coming from an organization that is inside the European Economic Area. So the GDPR does not define people by residence, it defines by where they are at the time.
Okay, let's talk for a minute about Friday. What would you say is absolutely essential that publishers have to have ready on Friday? Or is this some sort of mythical deadline?
Well, I'm not old enough, but back in 1939 in the UK, war was declared on Germany. And then there was a period afterwards called the phony war, because war had been declared, but nothing happened. So we will enter into the phony GDPR phase after Friday, because the subjects are too big. The ability to people to change is just not sufficient, for all the requirements. And so I'm expecting that, very little will change for quite some time. Obviously, there will be the bigger companies, and particularly the ones who are exposed and more likely to get addressed or attacked or fined, need to be very quick and do things, because next week they'll be sharpening the pencils on Facebook or Google. Also, the GDPR introduces the ability for individuals to sue for compensation, and even to do it as a kind of class action, group action. It makes a lot of rights for individuals free of charge, and people are developing tools to help those individuals, claim their rights. So over the forthcoming months, we're going to see a lot more individual activity as well. But essentially, I'm not giving you legal advice, but if on Friday they do the same thing as Thursday, then it's unlikely anything will happen.
Yeah, yeah. Have you heard, or do you have a sense of publishers that have been preparing for this, how it's impacted any sort of like organizational issues? I mean, in terms of hiring special staff, data protection
Well,
officers, or anything like that?
yes, yeah, certainly. Well, I mean, in data protection officers were generally required in Germany anyway before GDPR, and uh, under the GDPR, they're only required if you pass certain thresholds, and many publishers would not pass those thresholds. But most of them have been designating people to be, looking into the whole issue. However, publishers have their own focus. GDPR and is not a major focus of most publishers. That's not been the way they've been thinking. And over the last decade or so, many of them have allowed control of their revenue models to pass to the big players in the advertising industry. And so they don't necessarily have a lot of room for maneuver. So most of the publishers I'm talk to are kind of going to, do whatever Google tells them to do at the moment. And will be trying to work out something for the longer term.
Okay, we have a few questions here. Let's get to them, and we'll start with, this is Cesar, and he asked, what about Facebook widgets on publisher sites? How can we as publishers ask for user consent about what Facebook is doing with user data? How can we revoke that consent when the user requests us to do so?
Okay, well, if Facebook is collecting data from your website, it's because you're allowing Facebook to place a cookie or a pixel on your website. So that's under your control. So this is, the simple answer. I'm not sure what the commercial issues are, but
Yeah.
they will depend upon each situation. From the technical perspective, though, if it's happening on your website, you control it and you can stop it. And furthermore, you do have an obligation to the individual user who says, you're collecting data for Facebook via your website, you're acting as the controller, and so stop it. And so ideally, you will, at the very least, you will have some kind of a click point for privacy on your website, and people will have at least an email address they can send to in order to start executing their rights like that. How you execute it yourself depends, of course, on your whole construction, how you do your website, and what, of course, your relationship is with Facebook.
So Cesar follows up by saying, so I'll remove the widget altogether when the user asks.
Yes.
Okay.
Well, I mean, so yeah, for that user, I mean, if you could make a decision not to allow any Facebook widgets at all, right? But if one user asks you, it might be another user wants the benefit of that widget. So it's up to you, really, thinking of all the impact on everybody, whether you remove it for all your users.
Okay. Following this thread, Renjit has another question. Everybody, we're going to try to get to all your questions, I promise. Any specific things to be taken care if we use social logins like Facebook, Google, etc., to register to our website and subscribe to any of our services?
Well, yes, but when that happens, if you are using these other identity handlers to get people to log on, then those individuals are giving their personal data to the user, to Facebook or Google, whoever you're using. Now you're not liable for that. I mean, they decide to do so. If you put the thing, once you put it on the website, I think you probably should notify that the course they are entering into a direct relationship with Facebook, etc., by clicking. But essentially, when the information comes to you, then you will also be getting personal data, I expect. regarding the individual, and you need to handle that. But you're not liable for something which you can say is a direct relationship between an individual and the social media.
Okay. We have a question from Karsten, and he says, WP29 has said that the concept of a cookie wall is allowed, but to what extent can you use cookie walls?
Sorry, I do not believe that the WP29 has said a cookie wall is allowed. I think that would need a bit more clarification of the particular context you're talking about, but I'm not aware of WP29 any advice in that regard regarding marketing cookies stopping you getting to the website. Perhaps you could ask that person to clarify it. The question.
Yeah, okay, we'll see if he comes back. Could you explain just quickly what WP29 is?
Okay, WP29 is a committee of all the regulators in Europe, whose main job has been to issue opinions and guidelines to be followed when regulating data protection law, including ePrivacy, now the GDPR. On Friday, the WP29, which is at the moment just an advisory group, becomes a super regulator, let's put it. They don't directly regulate, but they become the supervisor for all the regulators in Europe, and they're changing their name to the European Data Protection Board. And so they, in some cases, will rule if the individual countries can't agree on how to interpret the law, they may give a binding opinion on the matter.
Okay.
Basically, they're the most authoritative regulator on how to interpret the law.
Okay. So we know that a lot of publishers are sort of playing it close to the vest in terms of what they're going to do about working or not working with Google or IAB. What is your take on that, or do you have any sort of general consensus of what you think most publishers will do, at least in the short term?
Well, I mean, you know, it does depend on commercial power. And we have already seen that some number of prominent publishers have publicly rejected at least the current Google proposal. I can't say what goes on behind closed doors. I think this just goes to what I was saying earlier, that publishers are now in a stronger negotiating position. But depending upon the individual publisher, they may not be in a very strong negotiating position. Also, this whole issue will take a long time to get resolved. It'll take a long time before people start getting fined for the way they're using cookies, or at least many people get fined. And so in the meantime, it's possible you could take an approach of accepting whatever is most convenient at the moment and planning your strategy for the longer term. The advantage of using a proposition such as Google is that they are definitely receiving legal advice on how to follow the GDPR. They are definitely very vulnerable because of the GDPR. So most of what they're saying is good advice and correct. The problem is when they try and shift it, they are trying through legal agreement to shift liability onto the publishers. But this is not really allowable under the law. Under the GDPR, the responsibilities are clear and cannot be shifted away through contract. So it's probably reasonably safe, I would say, from a legal liability point of view, to follow the Google rules for the time being, while finding what kind of other partnerships in the industry you can strike up to provide a combined approach to dealing with it differently.
What is some of the specifics around that liability that Google may be passing on to publishers? Is it the idea that vendors, they can't vouch for vendors? What is the
well, when you ask for a consent, you have to give you have to inform a user very well, tell them what purpose it will be used for, and some of the other points I mentioned, how long it will be used for. And then, based upon that consent, you send the data onto Google. So you are, in a way, vouching for how Google will use that data.
Okay.
So I don't think that Google would successfully press a case. I think if an individual was to sue for liability, it would be pretty easy to pass it on to Google if they hadn't provided the right information. But that's the area of uncertainty, and of course, it's untested legal area.
Okay.
Just a quick aside here. The Europeans and the European law tends to think of fundamental rights and looks to the regulations, whereas in the US, there's a lot more based around contract. For something to stand up as an arrangement under European law, it's got to be under European law. And so the contractual arrangements they try and put onto you from the United States will probably not hold up in Europe.
Okay. If you had to, this is from Cesar again, if you had to give a good example of a publisher who is requesting and handling user content in a good way regarding GDPR, is there somebody that you could suggest to look at?
Well, I mean, offline, I'll try and come up with some suitable answer to that question.
We can connect you with Cesar on that. We were talking about the different options for publishers. You spoke for a while again about the trusted agents. Can you explain who these are, or is this something that has popped up around this issue, or is it something that is in place already in terms of these companies or consulting firms?
Well, I mean, there are one or two organizations trying to offer things, but I believe that it really requires a combined publisher approach. I think for getting that sector underway, because those trusted agents will only work if the publishers tend to put their faith in them. So I'm hoping that the publishers themselves are going to promote it, but there are some organizations already doing some elements of this. And again, I don't want to name any names, but if people want me to provide information offline, I will do so.
Mm-hmm. Okay. How do you have a feeling? You were saying that, of course, that you don't think a lot is going to happen in the short term. I mean, what is the real threat here for the bottom line, in the sense of if publishers are, say, not taking this super seriously on the advertising impact, what could be in the short term?
Well, of course, if publishers don't do anything different from they're doing now, and they allow advertising networks to place cookies on their sites, and the advertisers carry on the same way as they're carrying on, then nothing changes, right? So the question is, who is actually taking steps to comply, and whether that might create a throttle. Already we're seeing, because of the Google move, they're saying they can't accept the cookies without it following a GDPR law. So already anything coming via Google is going to have to fit into this new arrangement, or they're going to have to use, say, the non-personalized network solutions. So there is going to be some immediate throttling of those advertising tech or advertising intermediary operations who only want to operate legally, and there is going to be less. I guess then there are going to be less people offering good programmatic advertising, but I can't speak very well on behalf of the advertising industry about how exactly they behave, because, as we know, the whole area of programmatic advertising is completely broken at the moment. I get flooded with adverts for personal sanitary products for 30-year-old women. I don't know why, but I'm being targeted for those all the time. So in between totally bad targeting, fraud that's taking place, the number of people who are wearing ad blockers. I mean, I just understand how the industry hasn't collapsed already. So it might just be that the GDPR will be the straw in on the camel's back, as they say. But if people want to still get their message out to individuals, they go through those gatekeepers who are the publishers. So advertising will still be there, and as much as advertising becomes more difficult to justify, the mechanisms, then quality advertising based on consent has a higher value, and so the prices should go up that people will pay for the advertising slots.
Okay, all right. We have one last question here, and it's for the audience that we have that's outside of Europe. As we all know, I mean, they have the same obligations if they have European residents or citizens visiting their sites. Is there anything, though, Robert, that you specifically would say to them regarding this?
People outside the EU, was that the question?
Yes, yes. Yes.
Well, there's a lot of misleading information about who is subject to the GDPR. So you only really need to worry if you are selling things to people in the European Union, or you are connecting to them, or you are tracking them when they're in the European Union. Of course, if you have any kind of global website, then that's on which you are running tracking cookies, then that's going to happen anyway. But it doesn't. You don't need to do anything when if they're European citizens or residents who are outside the EU, and you also outside the EU. For the rest, you legally under European law need to follow the GDPR just as much as anybody else, but it's unlikely that you will be the first one who gets fined. There is an obligation not to be forgotten that you should have a representative in the European Union, and so we can see that most non-EU organizations have not yet done this. And there is, in theory, a fine of up to 10 million euros for not having a representative in the European Union when you are subject to the law without having an establishment inside the EU. So you need to start looking at this issue of representatives. Once again, there are so many issues that the regulators again have to tackle that it's going to be non-compliance, but starting to try to do the right thing is probably the practical course for most people at the moment. I would say non-compliance only because it's so difficult for them to work out exactly what they should be doing about compliance at this point.
Okay.
I'm not encouraging non-compliance, so don't get me wrong.
Okay. All right, Robert, thank you so much. It was very helpful, I'm sure, for everybody listening. Thank you to the audience. Just a couple of last notes before we close. As I mentioned before, this webinar is being recorded, and we will post it on our YouTube channel. And tomorrow we will send an email to all attendees with a summary and a link to that to the recording as well. And I wanted to mention also that our next webinar will be late June. And speaking of publishers making alliances, that's exactly what this webinar is going to be about. We are doing a research report right now on publisher alliances around advertising cooperatives, and we're nailing down the date and who will be the featured speaker, but that will take place probably near the last week of June. So once again, thanks, Robert, and thank you for everybody attending, and we hope you're back at our webinars in the next month. Have a nice day.
Thank you very much.